problem I'd really like to hit on is the catch-22 with access to information. The reporting scheme obligates insurance companies to do the reporting. In order to do the reporting, you have to have a wide variety of personal information about the claimants, social security numbers or health insurance claim numbers. You have to have medical information, not just the payments made by Medicare, but you've got to have enough information in order to determine what the actual injury you're dealing with was so that you can compare it with Medicare records later on. And obviously there's resistance to that concept by plaintiffs. And oddly enough, the statute, after imposing the reporting obligation on insurance companies, did not impose a corollary obligation on the claimants to provide information to the insurance companies. And so we've got this struggle going on where the insurance companies need the information to report, but they can't get it. There's been an argument about whether there's a regulation requiring claimants to cooperate with CMS. And some people have tried to argue that that regulation obligates the claimants to cooperate with insurance companies in the reporting regime and to provide information. CMS suggested that for a while. There are two problems with that. One is the regulation talks about cooperating with CMS, doesn't really mention insurance companies. It's a little bit of a reach. And the other problem with it is it's not really enforceable, even with respect to cooperation with CMS. If the claimant decides not to cooperate, there's not much anybody can do about it. So it's a little bit precatory. Faced with that set of problems, insurance companies have tried a number of different approaches to getting information, all of which have some pretty serious flaws. There are informal requests for information, and I think in some areas of the country, plaintiffs' counsel have been making some real efforts to cooperate in those exchange efforts because they frankly see that it's in their own interest to do so. But in other areas, as I think we've heard this morning, there's been a lot of resistance to providing private information like social security numbers. There's been a move across the country, at least in those jurisdictions that have, for example, large asbestos dockets, to come up with case management orders that would require disclosure of information on a systematic basis in every claim. Those orders have suffered from a couple of problems. One is that some of them are not very complete in terms of the types of information that are disclosed. And the other is that some of them actually cut off follow-on discovery where there's an answer that's incomplete or more information is needed. Most of those orders are still in the debating stage. They've been proposed, there have been hearings in some cases. Most of the orders have not yet been entered by the courts, but there's some possibility that in time we will be able to develop a systematic approach so that at least in large docket cases like asbestos, there will be a systematic process of disclosure, but that's not happening yet. Another approach that people have taken is trying to get the information through discovery. The discovery requests pretty much always engender objections, and there's not a large body of decisions yet on how the courts are going to resolve those discovery questions.
I object to that comment.
I knew you would. I knew you would, Steve. And the final approach is to arrange for the exchange of information through settlement agreements that condition the settlement on an agreement by the plaintiff to provide the relevant information that's used to determine whether the plaintiff is in fact a Medicare beneficiary and to facilitate the reporting process. And that in turn has engendered some pretty tough negotiations in some cases and delayed settlements that probably otherwise would have been finalized a long time ago. So people are working their way through this. I think the bottom line for insurance companies is they're probably not going to be settling cases without some mechanism for getting the requisite information. They just don't have a choice, because if they fail to get the information and they don't report, then they face the possibility of the fines from Medicare and also the possibility of a Medicare recovery action for double damages, and they don't want to do either one of those things. A related issue is the question of a safe harbor. And last year there were high expectations that CMS would develop a safe harbor provision so that if an insurance company or a self-insured entity went out and requested information from the claimant in an organized way, they would be protected from the reporting penalties, whether or not the claimant cooperated in that process. When they finally came out with the form, however, it didn't turn out to be exactly what people had expected. Instead, they provided a form that could be sent to claimants, and they said, well, if the claimant signs the form and sends it back, you're protected. And the problem there is you have the same issues of cooperation or lack of cooperation that we've talked about. People are very reluctant to fill in those forms. And oddly enough, the form that CMS came up with has a space at the end of the form. I've never seen this before in a government form. It provides a space for the claimant to say, I am refusing to answer for the following reasons. So the chances that people are going to fill in those forms and send them back are not very high.